Having been served with the motion filed by the first defendant, which was brought pursuant to Order 64, Rule 8 of the rules of this Honorable Court, my Lord, in objecting strongly to this application, we shall state that first, it is a cardinal principle of law that provisions of law, rules, and statutes are not to be read or applied in isolation. My noble Lord, the Court of Appeal has settled this in the case of FCMB versus Consumer Protection Council 2021 Law Pavilion Electronic Law Report 55804, Court of Appeal. My Lord, it was stated that to avoid violence, the provision of any statute or any law must be read together. To ascertain the true meaning of that provision, it must be read as a whole. My noble Lord, they have brought their application via Order 64, Rule 8, Sub 1. But my Lord, Rule 8, Sub 1 does not stop at Sub 1. With the kind permission of my noble Lord, I shall read Order 64, Rule 8, Sub 2, and further. My Lord, it states, notwithstanding anything to the contrary, mere filing of application for stay shall not operate as stay of proceedings or stay of execution. The drafters of these rules of court they do not stop there. My noble Lord, Order 64, Rule 8, Sub Rule 3 states further that furthermore, the filing of an application simpliciter shall not be sufficient for the court to grant a stay of execution of the judgment of the court or stay of proceeding before the court in this instance. There is now a proviso saying that provided that where an appeal has been filed and all records of proceedings have been transmitted and an appeal has been entered, that is to say, the appeal has been issued a number, a court may, my Lord, on sufficient grounds, stay the execution of the judgment or the proceedings upon which the appeal has been entered. My noble Lord, the drafters of this rule, they have anticipated this kind of situation. They know that parties may come up with applications to forestall the proceedings of the court. In fact, today the case was slated for judgment, and the last adjourned date, which was 20th of May, the first defendant never knew that they would bring an application. It was the eve to the day of judgment that they woke up and went to file. My Lord, the exhibit they attached, the notice of appeal, the exhibit they attached, it was dated 18th day of July 2022. My noble Lord, in my own calendar, there is only one date like that, and that was yesterday. My noble Lord, they filed this notice of appeal, that is the exhibit attached to the application, yesterday. And maybe elsewhere, it is not done. There is no record that the record has been transmitted. They only filed it in order to forestall the progress. In fact, the dawning progress of his case, to file it. My noble Lord, on that, we urge my Lord to strike out their application and discountenance it. And my Lord, to add, application for stay of proceeding or stay of execution is not absolute. In fact, it is to the discretion of the court. With the kind permission of my noble Lord, once again, I read Order 64, Rule 8. Rule 8, 1, 2, 3, as read, and I will read the proviso, my Lord. The proviso. Provided that where an appeal has been filed, agreed, they have filed an appeal, and all records of proceedings have been transmitted, my noble Lord, there is no record of that before this honorable court, and an appeal has been entered, my Lord, an appeal can only be entered when a record has been transmitted. No matter how electronic the court of appeal may be, there cannot be fast transmission of record in 24 hours. There can't be. And in fact, there is no record, there is no proof that the record has been transmitted. That is to say, the appeal has been issued a number. Yes, it has been issued a number, but it has not been transmitted. The court may, on sufficient grounds, my Lord, this word may is the rider, and it has been explained judicially in several cases that the word may is a permissive or enabling expression and conveys a meaning that there is an option of doing or not doing the act, which means this honorable court, in his honorable discretion, can choose either to do or not to do. However, we urge my noble Lord not to do it in this instance case. My Lord has taken judicial notice of the lingering and the actions and the demeanor of the counsel from the beginning of this case till this time. We submit that this application should be discountenanced totally. And my Lord, finally, counsel raised and argued an issue of fair hearing. Sincerely, this fair hearing issue has now become a card that every party now throws at the instance, just to they can throw it at will. But my noble Lord, the courts have said, in the case of Liberty Bank and others, versus CBN and others, citation 2019, LPELR 50238 by the Court of Appeal. It says, my noble Lord there said, fair hearing is not a casual principle of law available to be picked up at will in a case and force the courts to apply to it to a party's advantage. My Lord, this principle is not a magic wand that can just be picked up by a party at will or at any time, because it is fundamental. We urge my Lord to discountenance the arguments inside the application, and in fact discountenance the application itself. And my Lord, we urge my Lord to exercise his discretion judicially and judiciously. We are most grateful, my Lord.